Now, before I introduce Dean, and we'll need to do that fairly quickly, Dean is a more recent recruit to the Victorian Bar, having arrived from the UK. Is it to play cricket, Dean, or is it only a couple of years ago? He tells me that he has married an Australian girl and now has settled in Melbourne. And Dean, I think, has the advantage of having practiced in England, and so can bring to his practice his experiences as a barrister in chambers in London, where he practiced for 5 years at the bar, and his area of specialisation there was tax offence litigation, insolvency and regulatory proceedings, and other areas which we would denote as sort of white-collar crime. And so I'm going to invite Dean to continue the discussion that Simon has begun. But before I do that, I'd like to announce the winner of the Door Prize. And the winner of the prize is Stuart Jessup from O'Donnell Salzano Lawyers. Stuart, are you here, sitting right down the back? Would you like to come forward, Stuart? Stuart, I've just got one question to ask. Are you part of the family where your old man barracks for Geelong?
I am, yes.
I see. Well, it's a great pity, but congratulations on winning the Door Prize. I'm sorry that we've invited this sort of Geelong riffraff to this morning's function, but Stuart, well done. There'll be a questionnaire on the book by 5 o'clock tonight, so that I hope you have read it from cover to cover. Dean, would you like to continue the discussion now that Simon has begun?
Good morning. As a recent transfer, I can confirm that the body of case law that's amassed around directors' duties here it's vast, and it's for that reason that I'm now narrowing it down to section 180, which seems to occupy most of the court's times with relation to directors' duties. In the UK, it was only in 2006 that directors' duties were actually codified. In the 2006, I think it's section 174 of the 2006 Companies Act, we find an equivalent to a section 180. Before that, it was all effectively general law, and there wasn't, up until the 80s anyway, there wasn't a great deal of case law that addressed the issue. Perhaps that was because breaching directors' duties wasn't the sort of thing that chaps do, and it was all dealt with at the club. Here, and it's to this jurisdiction's credit, these things seem to be far more high profile, and they certainly seem to involve some very high profile figures, not least the case that I was involved with last year, which was the ASIC, Fortescue and Forest case, to which I'll return in a moment. What we've done for the second half of the paper is looked at section 180 and some issues that the courts are grappling with, and rather than preface what those issues are, I'll launch straight into it. Simon mentioned before that section 180 deals with an objective standard. That's not to say that there hasn't been some sort of a conflict in the case law. And it looks perhaps as though that case law and the conflict may have been reignited by the recent decision of the New South Wales Court of Appeal in Morley. The first line of authority places primary emphasis upon the subjective skill and experience of the director, and some commentators, Robson in particular, they seem to find the origins or the recent origins to this line of authority in Santo at paragraph 372 of Asic and Adler, where he says that in determining whether a director has exercised reasonable care and diligence, one must ask what an ordinary person with the knowledge and experience of the defendant might be expected to have done. As I'll indicate and deal with in a moment, this is to some extent taking Santo's judgment out of context. What he's actually saying when you deal with the context is that it's an objective standard. But in any event, Justice Brereton in Maxwell took this and held that directors are not required to exhibit a greater degree of skill in the performance of their duties than may reasonably expected for persons of commensurate knowledge and experience. Now, query what persons of commensurate knowledge and experience actually means, but certainly defendants do and probably will seek to argue that commensurate knowledge and experience means, well, it's somebody having the same knowledge and experience as myself. And one can see from that, and certainly it's the commentators note, that this bears considerable similarity to the general law principle as found in city equitable fire insurance, that the court won't require a director to exercise any skills beyond those he or she takes to the actual appointment. In contrast, and this is certainly the line of authority that we say prevails, the Section 180 standard is found to reflect what is objectively expected of a person appointed to the office. So it's about the standard it's about the standard applicable to the office rather than the standard applicable to the individual person in that position. And the judgments of recently retired Justice Austin have been central to this development. In Vines, he examined the history of Section 232, subsection 4 of the Corporations Law, which we've set out there at the bottom of page 14. The wording of 232, subsection 4, differs from that in Section 180, subsection 1, but the only real, in effect, the only real distinction that the courts seem to have noted is the addition, I think, in subsection 1b of 180 of certain requirements which have been placed in there to make clear that differing standards can apply to executive and non-executive directors. In any event, Austin there in Vines says that the degree of care and diligence that a reasonable person in like position to the chief financial officer of a corporation would exercise in the corporation's circumstances is the objective degree of care and diligence flowing from the position. So again, it's about the position of chief financial officer. He also considered the formulation further in a later Vines case, and I've rehearsed there some of the basic facts, but perhaps moving on to paragraph 69. Well, first with 68, Austin found that the requirement in the formulation to compare the particular officer with a person in a like position enabled the court to look both at any special expertise held by individual directors and the distribution of functions within the corporation. And he then concludes that the statutory formulation adopts an objective standard of care, measured by reference to what a reasonable person of ordinary prudence would do. He doesn't actually mention the position there, but it's implicit now, I think, from the word objective. And then that objective, to some extent, minimum standard is enhanced where an appointment to the board of directors is based on the appointee having some special skill. by an objective standard of skill referable to the circumstances. Now that decision was appealed to the New South Wales Court of Appeal, and the appellate court, Chief Justice Spiegelman noted Justice Austin's views as to the nature of the section without disapproval, and Justice of Appeal Santo, who was dissenting, though not on the proposition of law, he noted that the section applies an objective standard of care, diligence, and implicitly skill. So notwithstanding the fact that Brereton had managed to derive a much more subjective formulation, apparently from Santo's formulation in Asic and Adler, Santo is now saying that it's certainly about an objective standard of care by reference to what a reasonable person would have done in Mr. Vine's position with his ongoing responsibilities as Chief Financial Officer and with his additional responsibilities by reference to GIO's circumstances and by reference to the powers to be exercised and the duties to be discharged in that position. To draw this line of authority to its conclusion, it was on this basis that Justice Austin was able to conclude in Rich that it seems to me, in light of Vine's, the earlier view, Justice Brereton's view, that directors are not required to exhibit a greater degree of skill in the performance of their duties than may reasonably be expected for persons of commensurate knowledge and experience in the relevant circumstances, is no longer correct. So that's what we were left with at the end of Asic and Rich. However, in Asic and MacDonald, number 11, Justice Gazelle followed the Maxwell line of authority. And I'm sure you'll all know the facts in MacDonald. Essentially, it revolved around James Hardy and disclosures that were made to investors and the ASX about liabilities to which they'd be exposed by virtue of asbestos-related litigation. Over the page at 78, Justice Gazelle held that draft announcements were misleading because of the unqualified statements contained. And by virtue of the approval of the statements, the non-executive directors present were found to have breached their duties under Section 180 in voting to approve the announcement. US-based non-executive directors who seem to have attended these meetings, if at all, by telephone, they breached their duties by failing to request a copy of the announcement and failing to familiarise themselves with the terms, or in failing to abstain from voting on its approval. Mr. MacDonald, the Chief Executive Officer, breached his duty in voting to approve the draft announcement and failing to advise the board appropriately. Mr. Shaffron, the Secretary and General Counsel, he breached his duties as an officer in failing to advise the board appropriately. Mr. Morley, the Chief Financial Officer, breached his duty in failing again to advise the board appropriately. And there were then further breaches arising out of a deed of covenant and indemnity, and we set out Mr. MacDonald's and Mr. Shaffron's breaches there. Now, the important part for present purposes is that in arriving at these conclusions, Gazelle considered the standard required by Section 180, and he followed Justice Santo's proposition from 372, which Brereton took to be akin to a subjective standard, and then he adopted specifically Brereton's analysis from Maxwell. In the recent decision of the New South Wales Court of Appeal in Morley, which was the appeal decision arising out of Asic and MacDonald, one of two decisions arising out of ASIC and McDonald. And this, of course, was an appeal. McDonald didn't appeal. The non-executive directors did appeal, as did, I think, Shaffron and Morley. On the one hand, the court referred indirectly, obliquely, if you will, to Brereton's proposition from Maxwell without disapproval. But on the other hand, and apparently without noting the contradistinction, the court almost immediately noted Austin's position in Vines as approved by, or at least taken up by, Spiegelman on appeal, to the effect that the standard encompasses an objective standard measured by reference to what a reasonable man of ordinary prudence would do, enhanced where the directorial appointment is based on a special skill by an objective standard of skill referable to the circumstances. So we still seemingly have some window left open to Brereton's formulation. My view, and Simon shares it, is that it may just have been a slip-up on the part of the New South Wales Court of Appeal, but certainly it's the objective position that prevails. And Austin was quite clear when he said, this is in ASIC and Rich, he was quite clear when he said Brereton's view in Maxwell is no longer correct. Now, moving on, because we have these objective standards, there has been some increasing tendency to identify core components of what that objective standard would be. Back in the 90s, in AWA and Daniels, whilst Justice Rogers held that at common law you couldn't fairly be expected to contribute, or at least a non-executive director couldn't be fairly expected to contribute anything more than decisions on questions of policy, the appellate decision found that all directors were required to take reasonable steps to place themselves in a position to guide and monitor the management of the company. And the court then went on to outline what those core components to the duty would entail. Specifically, a director should acquire at least a rudimentary understanding of the business of the corporation, and specifically the fundamentals of the business in which the corporation is engaged. Directors are under a continuing obligation to keep informed about the activities of the corporation. Directorial management does not require a detailed inspection of day-to-day activities, but rather a general monitoring of corporate affairs and policies. And as a result, directors would be well advised to attend board meetings regularly. And finally, whilst directors are not required to audit corporate books, they should maintain familiarity with the financial status of the corporation by regular review of financial statements. So even then, the court was saying the days of being a director, never attending, having no involvement whatsoever, except perhaps the odd chat at the club, those days are well and truly past. In ASIC and Rich, now we set out the facts there, but in ASIC and Rich, the Austin took up this position and to some extent built upon it. Over the page on paragraph 102, we see that he basically reiterated the standard in Daniels, saying that statutory duty requires every director or officer to be familiar with a company's business, informed about the company's affairs, monitor, and to be familiar with the financial status of the company. But in addition, he said that the statutory duty encompasses a duty of competence measured objectively, and then we have the previous formulation there at A, but that the standard includes a standard of competence in reading and understanding financial material. which is not dependent on the director's sub-duty, inexperience, or lack of skill. And directors and officers cannot escape liability because they did not read financial material made available to them. Now, notwithstanding these core components to the duty, the courts do, and they do acknowledge, and they continue to acknowledge, that the standard of care and diligence required will vary depending on the circumstances, and those circumstances can include a number of things, and in particular the facts of the case and the nature of the director's role. As Sir Richard Scott, Vice-Chancellor, noted in Bearings, which was one of the few English cases to actually deal with directors' duties. It arose out of the Bearings bank collapse and spawned, well, a good decade's worth of litigation. The higher the office within an organisation that is held by an individual, the greater the responsibilities that fall upon him. Sir Richard Scott went on to point out, and this perhaps is something of a riposte to Simon's rhetorical question as to why it would be that you'd become a director. Sir Richard Scott went on to point out that the higher the responsibilities, the higher the rewards as well. Let's not forget that directors are generally rewarded for their positions. So we turn to the question of the director's position. And whilst it's clear that position can affect the content of the duty, the law certainly is not yet clear as to the extent to which that's so, and Gazelle in Assoc and MacDonald noted as much. And I'll skip over Gallagher. Turning to Assoc and Adler, as I'm sure you all know better than I, Adler was a non-executive director of HIH, and the court also found him to be an officer of a subsidiary, HIHC, HIH Casualty and General Insurance Company Limited. The facts there are rehearsed. Now, the point arising out of Assoc and Adler is that where a non-executive director occupies a position such as a chairman of a company, as Adler did, and chairman of the audit committee, there'll be a question as to whether he's subject to a special standard of skill and diligence. Now, that exact question was considered in Assoc and Rich, and we refer there to a very good article by Keeves called Director's Duties, which looked at the early part of the Assoc and Rich litigation. In Assoc and Rich, Greaves was the chairman of the company and also the chairman of the Finance and Audit Committee, but he's still a non-executive director of Wantel. Assoc alleged that Greaves had special responsibilities beyond those of the other non-executive directors by reason of the additional positions he held and also by reason of his qualifications. He was a chartered accountant, he had substantial practical commercial experience in listed public companies. The special responsibilities that Assoc alleged Mr. Greaves to be dealing with are listed there in paragraph 118. It's about ensuring that the board adequately, properly and promptly address the soundness of the underlying financial position. So again, we have the preoccupation with the financial position. He had to ensure that there was a functioning and effective Finance and Audit Committee, and as chairman of the board, he needed to establish that the board had a process for ongoing internal review by an internal auditor. Now, it can be seen that these special responsibilities related not to the duties of company chairman generally, but to the duties of a company chairman who is also the chairman of the audit committee, with particular reference to that person's special qualifications. And to cut a long story short, the court refused Mr. Greaves' application to have the cause of action dismissed, and eventually Mr. Greaves agreed that he'd contravened Section 180, and we there set out exactly how that was so. The court, this case also illustrates the significance of the factual context. The court stated that the general duties of Greaves extended to carrying out the responsibilities outlined by the court in the particular circumstances of Wantel between January and March 2001, because it was during that time that there was a progressive and substantial deterioration in the financial position of Wantel, including trading losses of some 83.6 million. So we have position, and behind it we have the factual context in which the company is operating. All of those factors can operate upon the contents of the duty in Section 180. Even so, and this Simon dealt briefly with the question of reliance, the general position is that non-executive directors are more able to rely upon delegated responsibilities. Now that question, we've set it out there. There's not a great deal that can be said about it. Certainly in Morley, the court just says, well, that's the general state of affairs. I think we can expect, by virtue of the central litigation that's going on at the moment before Justice Middleton in the federal court, that there will be some additional jurisprudence on this very issue. That case, from what I understand, concerns whether non-executive directors in particular have been properly able to rely upon the audit provided by, I think it was PricewaterhouseCoopers. Now, again, as Simon suggested, you've got reliance on the one hand, but you also have the question of red flags, and I understand that that's essentially what the issue in that case is about. I'll deal very, very swiftly with directors' duties and the contravention of other provisions. I'll try to do it in a minute. Not least, I want to deal with it because it's at this point that we get to the most important recent case. That's mine, Assoc and Fortescue. The point is, certain provisions in the Corporations Act don't have a civil penalty provision. You take Section 1041H, for example, there's no civil penalty provision. Now, that doesn't prevent conduct in breach of Section 1041H, which is misleading or deceptive conduct provision. It doesn't prevent conduct in breach of that provision also leading to a contravention of Section 180. And the way that the courts have found you can do that is because a contravention of a non-civil penalty provision may lead to civil liability, the director is jeopardizing the position of the company. And if you're jeopardizing the position of the company, you are also likely to be breaching Section 180. That section's well worth reading for obvious reasons. Now I think I'll finish there. I don't know if we have time for Section 180 subsection 2, which deals with the business judgment rule. We probably don't.
All right. Well, we may do. It just depends on whether people would like to ask questions. But Dean, you're going to be a dangerous advocate, I can tell you, because you have this very nicely detached, gently modulated English accent, which means that no matter the submissions you may make to the court will be utter bunkum, they will sound like they are completely persuasive. So what that means is you'll be able to charge a premium on your brief fees. But thanks very much, Dean. What you've exposed is this continuing tension between the objective requirements which are imposed on on directors who are, after all, looking after the investments in the company by shareholders, with the subjective consideration of their own knowledge and experience. And I suppose courts are thinking that if we are too onerous, we'll never get anybody to become directors in companies, and we need companies as the engine room of commerce. But it's also interesting in comparing and contrasting the phases in which these cases go. In Victoria, before you arrived, we had a sequence of cases, really beginning with the collapse of the State Bank of Victoria and Tricontinental and Mr Johns, and in the Royal Commission which was conducted into the collapse of the State Bank, there's a very interesting, although now historic, discussion of the role of non-executive directors. Then I think it was before or after we had the collapse of the National Safety Authority, and Mr Friedrich, gosh, how these names dominate the headlines for a few years and then they disappear. And of course the collapse of Faro Mortgage Services in Geelong, which also had profound consequences for the Geelong community and wider. More recently, it seems that Sydney has been the forum for the more significant cases on directors' duties. And there is in Australia, of course, Dean, a sort of a Melbourne-Sydney thing. It's no surprise that in the last 10 or so years, the largest cases of corporate egregious behaviour in Sydney, because that is sort of sin city, whereas in Melbourne we're much more pure, and we've learnt from our past mistakes. But I want to thank you, Dean, for your paper, and I'd like to ask you all to thank both our speakers for the time in which they've put into the preparation of the paper. I'm conscious of the time and everybody's need to be elsewhere, but I am sure that Dean and Simon will be about for a little while longer if you'd like to ask questions of them. Conference with the leader, so he's out. Looks like Simon might be fielding all the questions, but thank you very much for coming this morning. I hope that you have found the presentation as interesting as I have, and I do recommend the paper to you because it really repays close study, and I think it's a real advantage of bringing us up to speed with the current status of the law on directors' duties. So thank you very much and enjoy your day.